All right, welcome everybody. It is our monthly YouTube live show, Work Comp Today, where David and I coming out of Birmingham, and we typically will have on the show a friend, a colleague, somebody around the country who does the same kind of work that we do, and we talk about the topics of the past month that impact employers, employees, and independent contractors. Dave, you've got that usual smile, that welcoming look on your face today. I know you're so excited for another episode. How's your day going today, bud?
It's great. And my enthusiasm cannot be controlled because, Alabama is in the Sweet 16 and we play tomorrow night for a chance to go to the Elite Eight.
That is true, but really, some would say the better answer is because of our guest. That's why you have a big smile on your face.
We do have a great guest today.
We do. We've got a longtime friend and colleague out of South Carolina, Bill Smith. Bill, thank you again for making some time, and I want to apologize for my brother's behavior over the next 45 minutes.
I'm used to it, no problem. And here in South Carolina, we care about the Sweet 16 for women's basketball, by the way.
Right.
Just as a side note, if you haven't seen the history of SEC hoops or Southern hoops on ESPN, fantastic series, and South Carolina basketball for women particularly is all in several of those episodes. Dawn State, oh golly, just a juggernaut of a team. But anyway, guys, we are going to kick off as we usually do. We've got a series of about 5 or 6 articles that we have found through the internet over the past month. And we're going to run through those, and then we're going to talk about some comparisons between Alabama and South Carolina laws and procedures. But before we do, Bill, tell us a little bit about your practice and life in South Carolina.
Sure, thanks. I'm a workers' comp lawyer, just like you guys. I've been doing this for 38 years now, and I'm embarking on a new chapter in my life right now. For 30 years, my law firm was Chapel, Smith & Arden here. We've gone through a little recent change. One of my partners retired, one's going off to practice with the son. So we've had a little reorganization here, and all very amicable. But my new firm is Smith, Bourne, with Venice, Taylor, and Vega. So we've been at it for about a month now. So we're very excited about that. But like I said, I handle exclusively workers' comp claims. My firm handles workers' comp and personal injury cases. I've been a past president of Willard, which David will be here in a few years, and that was one of the most rewarding things I've ever done professionally. So that's enough about me.
Well, I'm glad that you brought up the organization, Will. We bring them up each month, and typically we have as our guests colleagues, like I said, who do same or similar kind of work that we do around the country, but they're also fellow members. So Dave, I'm actually going to allow you to speak this episode. And if you would, just share a little bit about the national organization that Bill has been a past president, and now you're in the chain of command, working your way up with on the executive board.
Sure. So Bill is a past president of the organization, and that's how we got to know him. And what we're talking about is the Workers' Injury Law and Advocacy Group. It's a nationwide organization made up of claimants lawyers or lawyers that represent injured workers. And I think we're about 1,200 strong now representing. We have lawyers from every state in the country, and it's lawyers that do workers' compensation, Social Security disability, Defense-Based Act, Longshore Act, and as well as FECA. And we get together several times a year around the country. And it's great for us to be and to hang out with the best and brightest work comp lawyers in the country and get to learn from them and have relationships with great lawyers around the country. So we're big proponents of the organization, and so glad that we've gotten to know people like Bill through our membership.
You're so right. Just from a networking standpoint, my gosh, we could probably name lawyers in almost every state as a result of being in this. But we'll come back and get Bill's perspective in a few minutes. But let's jump off on our first article, fellas. This one's out of California, and surprise, surprise, the gig economy is in the news. California court mostly upholds Prop 22 and a win for Uber and other gig companies. Dave, I'm going to start with you on this one. And I bet we have mentioned gig economy in about half of our episodes over the last 3+ years.
Yeah.
Any takeaways from an Alabama perspective that we may be able to help advise our clients?
Well, I mean, let's talk a little bit about what gig economy is and independent contractors versus employees. And I'm going to be brief because I know that Bill has been immersed in this over the last several years through Willie. But essentially these gig drivers or Uber, Lyft drivers, the companies consider them to be independent contractors. And what that means is they don't pay unemployment tax on them. They don't pay work comp. They don't have to provide health insurance, and they don't have to pay other benefits. And it keeps the company's costs down, but it leaves a lot of those employees, those independent contractors without the safety net of workers' compensation and unemployment compensation and health insurance. And so this is specific to California, and this was considered a win at the appellate level for these big companies. In other words, the law was upheld that the drivers are independent contractors and not considered employees. So with that, I'm going to be quiet because I know Bill's got a world of knowledge on this subject.
I don't know about that, but California has been at the forefront of this fight, and this fight's going on all over the country. It kind of started in California with the Dynamics decision a few years ago, and out of that came something called the ABC test, which was one of the better tests for employees across the country that kind of classified more of these folks as employees than as independent contractors. Well, Uber and Lyft and these other folks then put $220 million into this campaign for what we call Prop 22, which was to completely do away with that decision in the Dynamics case. And spending all that money, they won. And then this decision came forth that kind of supported that. It looks like it's going to go on up to the California Supreme Court, and we'll see what happens. But interestingly, one of the things that Uber says is they're not a ride share company. They sell apps. And when I go out to dinner with my wife and I've had that one too many glasses of wine, and I reach for my phone, I think I need an app. I don't need a ride, so I call Uber. But this is a fight all over the country.
And it's probably going to continue for the next several years as well. And we'll keep trying to report on it anytime there's been some court news. So we'll put a cork in that for now. We're going to move to Pennsylvania. This one got my attention because next month I'm actually speaking on this issue in a work comp and medical marijuana topic. In Pennsylvania, the Commonwealth Court rules that work comp should cover medical marijuana costs. Bill, let me start with you. In South Carolina, have you dealt with this issue? Is it something that is covered, or are you familiar with it?
We do not have medical marijuana in South Carolina. So now it's proposed every year, but it has not passed. So it's not an issue that I deal with in my day-to-day practice. When I was president of Willie, this was an issue that was going on around the country. So I had to, one of the things Willie president does is you go around the country and speak on issues and help states with the fights they're in. So I certainly was aware of it. I think with this decision, Pennsylvania becomes the 7th state that does allow reimbursement to injured workers for medical marijuana. And, it certainly makes sense. The years, just think back a few years ago, one of the big fights was opioids. Insurance companies did not want to pay for opioids. They were expensive. And obviously there were problems with opioids, but aside from that, the big fight was over cost. Yeah. Now there's a cheaper alternative, medical marijuana, and insurance companies still don't want to pay for that. They want to fight that. If you look at it from a policy standpoint, there's a lot of things that workers' comp acts don't do. There's so many benefits that you can recover in another type of case you cannot recover in a workers' comp case. But the one thing that consistently workers' comp does provide is medical care. So why in the world, if an injured worker is being prescribed medical marijuana as part of their medical treatment, and it's a cheaper alternative than what they would otherwise be prescribed, why shouldn't they get reimbursed for that? It just doesn't make sense to me.
Here, this is typically where in the show, Bill, and thank you for that, is where David talks about how advanced Alabama work comp laws are in protecting our workers. He loves this part of the show. So I'm gonna let David do his thing now. The Alabama response to this issue.
Look, I'm afraid if I even talk about medical marijuana, I could get arrested, I'd be worried about it. But, Bill brings up a great point. We talk about, people getting addicted to opioids and the opioid pandemic, the opioid crisis. Well, what's the alternative, right? If they're not taking opioids, well, what are you going to do for them? And so medical marijuana is certainly a viable alternative in so many states, but not in Alabama. And I wanted to point out one interesting thing here that was in the order. The judges said that the employers are not being ordered to break federal law because they're not being required to pay for marijuana, but rather they're reimbursing the patients for the medical costs. So that little distinction right there is very interesting.
Yeah, I think there was, I know that's been some states that have ruled against it. That's one of the things, the reasons that they ruled against it. They're saying an insurance company can't violate federal law, but people, as you said, they're not paying for it. They're just reimbursing the injured worker.
That's right. Employee comes out of pocket, pays for it, and then gets reimbursed by the insurance company. Yeah,
Right.
That's right. It's interesting, little distinction there, but it's interesting.
It is. All right, fellas, we're gonna move on to our third article. This comes out of Georgia. And unfortunately, this topic has been a topic for us many, many times. Georgia business owner sentenced in $54 million workers' comp fraud. And when I got into that article, how big it had blown up to. David, did you get a chance to digest this one a little bit?
Yeah, a little bit. It was some very creative number crunching / fraud going on by this Wesley Owens out of Atlanta and his business partner, Bo Wilson, also of Atlanta. And we talk about fraud, work comp fraud pretty regularly on the show. And it cuts both ways. You hear about individuals, receiving temporary total disability checks, but they're also working. Well, that's typically fraud, and they can be prosecuted for that. But that pales in comparison to the employer or business and insurance side when you're talking about the volume of money involved. And I think, Bill, you may know the North Carolina lawyer who publishes the top 10 fraud cases each year. And sometimes you'll have an employee in there, but the volume, the amount of money that is that's costing the insurance side when the employer's involved in fraud is so much larger than the employee side.
And that isn't it typically your premiums, if you're an employer trying to figure out how much you need to pay in work comp benefits toward your policy, isn't it based on payroll and how much you report and pay taxes on? And if you try to hide or decrease what the actual payroll is, that's where you find yourself getting into some fraud-like activity.
And the other thing they do is misclassify employees. They'll try to classify 30 roofers as clerical workers. And, and you're right, David. Lynn Jernigan, our Willie buddy out of North Carolina, does the top 10 list every year. And it's just the stuff he puts in there. It's just amazing what you find around the country. And most of it, as you said, is employer fraud.
Well, it is, again, it's something that unfortunately about every other episode here, we have that just as a little reminder to all of us what not to do. All right, here's a topic, Bill, that I suspect you, David, and I talk about not daily, maybe weekly or monthly with our clients. What is the difference between workers' comp and short-term disability? And just in general terms, Bill, if you could, what do you tell your clients, those folks that are really needing some guidance on which way to go? And can you get both? Can you not get both? What do you share with them?
So in general, when you're injured on the job and you're out of work, you're going to receive workers' compensation, what we call temporary total disability benefits, 2/3 of your average weekly pay while you're out of work. For a non-work related injury, if your employer has a short-term disability plan, then you will receive short-term disability, which is usually about 60% of your average weekly pay. Also, workers' comp benefits are not taxable, whereas short-term disability benefits typically are taxable. And I don't know what you guys see, but we typically see 3 different types of short-term disability benefits. Some plans will completely exclude on-the-job injuries. So if it was an on-the-job injury, you're not going to recover any short-term disability. The second type will pay if it's an on-the-job injury, but there is a set-off for other income. And your workers' compensation benefit or Social Security disability or any other benefits you have like that are other income. So it reduces it completely or to the minimum payment, which is $50 or $100 a month. So you may be able to recover your workers' compensation benefits and another $50 or $100. The third benefit or the third type of short-term disability is something we almost never see. And that's when somebody buys their own personal policy. It's not provided by an employer. And it would pay regardless of whether it's workers' comp or if it was an on-the-job injury or not an on-the-job injury, and oftentimes even without a set-off. But I almost never see those plans. So generally speaking, workers' comp is going to pay for an on-the-job injury. Short-term disability is going to pay for not an on-the-job injury. And then I think you'll probably get into it when you have subrogation issues and that sort of thing as well on denied claims.
David, why don't you head in that direction with how does subrogation factor into here?
Yeah, so if the employer pays the insurance premium on that short-term or long-term disability policy, at least in Alabama, then they have the right of subrogation, which means they can seek a credit for the monies they paid if the injured worker receives a work comp settlement or receives a monetary award at trial. It's something that I've noticed recently, and I don't know if this is because human resources employees or human resource departments don't know the difference in work comp and short-term disability, but I've noticed that a lot of my clients who are going out on missing work because of surgery related to their work comp claim. They have an open claim and they're going to miss work because they're going to have surgery. Well, HR has been sending them the short-term disability application. And a lot of clients don't understand the difference. They don't know that they can't usually receive short-term disability and receive work comp checks while they're off work. And it's a confusing situation to them. And the client's just looking to make sure they've got some money coming in while they're off work. And not sure why these HR employees are doing that to the employees.
And lately I've had 2 clients go out for surgery and they are immediately put under FMLA. And I don't know what goes on with these HR folks and why they feel they need to mess up what's going on, but all it serves is to confuse our client, the injured worker, and it creates more work for us. But the reason why I brought this article up is because as you guys who are watching this are hearing from Bill and from David, it is a real world issue, a real thing that we've got to deal with and help explain to the injured worker, our client, how to navigate those waters, how to make it less confusing, because all of this can be confusing, even sometimes to those of us who've been practicing for quite a while. So I'm glad that you guys were able to explain what's going on in that. So thank you. And this would be, if we had any sponsors, this would be the time in the show where we would talk about those sponsorships. So since we don't, I'll reintroduce Bill Smith as our guest in our monthly YouTube show, Work Comp Today. David and I talk about, with our friends and colleagues from around the country, issues that are current topics involving the employers, employees, and independent contractors. Now, Bill, had you been here during football season, David would have subjected you to quite a bit of harassment about the gridiron and results. So this is going to be a much shorter episode. So I'm just giving you a little bit of heads up on that. But thank you for joining us otherwise.
I get that from David when I see him at a village event or by email. So I completely understand.
I'll say this. I've been Bill's guest in Columbia for Alabama USC tailgate and football game, and I highly recommend, if you're a friend of Bill's, to go do that. It was a great weekend in Columbia, not just because Alabama won, but because I was hanging out with my friends, and Bill's a great host. His law firm's a great host, and we ate well and had a good time.
Well, Bill, you got a little taste of snippets every once in a while when you see David at conferences or football game tailgates. Try being his business partner for 20 years and being his brother for quite a bit more than that. So we feel my pain there, Bill. So we will move on to the next article, fellas. And David, I'm going to start with you. Average work comp multiple injury settlement. This is not an everyday thing. But it is a very real thing when you have your clients who don't just have one injury, but they have either multiple injuries in the same claim, or they've already got an existing claim. They come back to work and they get hurt again on a different injury. So kind of navigate a little bit about how to deal with those situations for the client, Dave.
Yeah, well, I could talk for 30 minutes on that, but I will not subject y'all to 30 minutes. I'll try to keep it about 30 seconds so we can hear from Bill. I'll say this about Alabama law. In Alabama, you can get paid based on a schedule, meaning certain body parts are worth certain amounts of money in what's called a schedule of injuries. In other words, your fingers, your eye, your legs, your arms, those body parts have a certain set value under Alabama law. And unfortunately, they are among the lowest payouts in the United States. Now, if you injure your hips, your shoulders, your back, your neck, or if you have a psychological injury, then you're not limited to a certain schedule of benefits. And so we kind of start with where's your injury, what body part? And then we determine, do you have a vocational loss? In other words, do you have work restrictions that are going to prevent you from going back and doing that job, or prevent you from making the same or similar pay? So I'll just kind of hit pause there and turn it over to Bill to talk about South Carolina.
It's somewhat similar. In 1972, our legislature decided how much each body part was worth. There have been some amendments since that time, but it's primarily the same as it was in 1972. And if we have an injury that is limited to one body part, then we are capped at whatever the schedule says that body part is worth. For example, an arm's worth 220 weeks. If I have an injury in my arm, I'm going to recover some percentage of 220 weeks, even if that injury means I can never work again. So here we are, that's what we call a specific disability. We're trying to get the general disability for someone who's had a really catastrophic injury and can't work or has a significant loss of earning capacity. So to do that, I have to show more than one body part involved. So that's constantly what we're trying to prove. And it happens all the time. If somebody has a knee injury, they walk with a limp, or they have a knee replacement, they're on crutches, they're on a walker, progression through that, so they have the altered gait. They end up with back problems, or they end up with opposite knee problems. We see that all the time. Or somebody has a really terrible injury that becomes depressed. We have to show that they have a psychological injury on top of their physical injury. But if I can get past that one body part, then I can recover quite a bit more for them than I can if we're stuck with the one body part injury.
Well, thank you, Bill. I don't want to depress David further by talking about the differences in the payout. So we will not go to that normal, here's how bad Alabama law is segment of the show. But we're going to move on to, and I saved this one for this last article for a reason. 7 things not to do while on work comp. There's clearly more than 7. We have to preach and re-preach and just remind the clients, don't do X, don't do Y. And the reason being, before I come to David about this, I've always held the belief that no matter how bad the accident is, no matter how terrible the injuries and the recovery is, if the client, the injured worker, is not believable, if they're not credible, then the rest of the case doesn't matter. Does the story line up? Do the medicals match the story? Do you believe them? And David, why is credibility? Why is that along the lines of this topic, things not to do? Why is that so important that we have to keep stressing it to the client over and over?
Yeah. Well, I'm going to fast forward and say, and put us at the trial. Say you're at a trial and your client, the injured worker, is on the witness stand. Typically in a work comp case, the most important testimony that's going to come into evidence is the injured worker. Mm-hmm. And it's going to be that judge listening to that injured worker's testimony. And the judge has to believe the injured worker and find him or her to be credible. But that's at the trial. But back up, a year or two from the date of the accident, and you build credibility from the start. From the reporting the accident to the statements being consistent from what they tell the injured worker, from what they tell the insurance company or their employer, to the medical records, and then their deposition and going so forth. So yeah, our number one rule for our clients is tell the truth. You got to be honest.
Bill, what do you find is the biggest hole that your clients may step in, not literally, but virtually, that creates a problem that you have to then rehab their credibility or clean up during the representation?
And first of all, I completely agree with everything you just said about credibility. And going back to work, one of the biggest problems that you have is that the employer treats the employee completely different in many cases once an injury occurs. How many times do you see you've got a guy that's been there for 10 years, perfect attendance, great performance reviews, and all of a sudden they get hurt and they are treated terribly. All of a sudden they're a liar and a thief because they got hurt. Well, you have to teach your client not to react to that. They still have to be the same person that they always were. And no matter how poorly that employer has treated them after the injury, if they're released to go back to work, they got to try to go back to work. If they're released to light duty, they need to go try to do that light duty. And I tell clients all the time, it never hurts you to return to work. The one of two things is going to happen. You're either going to go back to work and you're going to be successful. And if that's the case, you're better off than you were on workers' comp, or you're not going to be successful. And if you're not successful, that helps me prove your case. It helps me prove your disability in this case. And so many times, because of the way they've been treated, they do not want to go back into that situation.
Yeah, there may be personality conflicts at this point. There may be a lack of confidence in returning into the workplace. I mean, there's a whole host of reasons, maybe bad blood at this point. But fellas, that takes us through the articles section, if you will. And before we pivot to the last section, Bill, which will be a comparison of South Carolina policies, procedures, laws in the comp world with Alabama, I want you to share a little bit more about WILG and why you have found it to be just so invaluable. And if I'm a lawyer who does this kind of work, no matter where I am in the country, why would it be something I would consider joining?
Yeah, I tell this story. I joined because they had conferences in really great places I wanted to go to. However, when I got there, I met amazing people, fantastic lawyers, the best lawyers in the country that do workers' comp, that were amazingly nice, helpful, and quickly learned that the problems that I have in South Carolina are the same problems that lawyers that do what we do are having in Oregon or Minnesota or you name it, or Alabama. And it has been completely just invaluable to my practice. And I can't stress enough the friendships and relationships that I've made through Willie. I mean, you guys, so many other people just like you. It's amazing that I have all these great friends that are all across the country that are as good friends to me as my next door neighbors are. And I'll tell you one other quick thing. I mentioned earlier I was privileged to serve as president. Every year at our annual convention, we have a past president's dinner, which I've been able to go to 3 or 4 times now. But we celebrate our incoming president, our outgoing president, and all that. And I got up and made a toast at this president's dinner and said, you know, there are lots of groups you want to belong to. I would love to be a member of Augusta National, but I don't think they're ever going to happen. But I wouldn't trade that for being a member of that organization. It's that good. And any workers' comp lawyer around the country that's watching this that is not a member of Willie needs to pick up the pen and paper or go online and join today.
Couldn't say it any better. Thank you, Bill, for that.
That was awesome.
The one,
Bill's right. It's the people. It's the people that make up the organization that make it so great.
And they are all so dedicated to their clients and making things better for injured workers across the country.
one last thing on this note. How many times have you sent out a message into the listserv about an issue you've got in your practice where you've gotten a dozen or more responses that day from around the country of things to kind of crowdsourcing? And it's amazing, the responses and the giving of time and their resources and their experience, because there does not appear to be jealousies or territorial disputes, if you will, that lawyers can notoriously be. I love that aspect of it as well.
And brilliant stuff too.
Yeah. When I'm sitting in those rooms, listening to those lawyers, whoo, I'm glad I'm listening to them and not having to talk in front of them. Fellas, let's move on to the last section. We got a few more minutes. This is where David really gets depressed, but we're going to plow through. Let's talk about attorneys' fees. How do attorneys in Alabama, David, get paid for the work they do? And then Bill, I'll come to you with the same question about South Carolina.
We get paid slightly. The attorney fee in Alabama for workers' compensation claims or workers' compensation cases is capped at 15%. Capped at 15%. So if we settle the case for $100, the attorney fee is $15. So it's a contingency fee contract, and the injured worker doesn't have to pay any money out of pocket to be represented by a lawyer in Alabama.
Bill, David often says we work for tips. What about South Carolina? How do you guys get paid for the work you do?
Well, it is also a contingency fee basis, but it's different than that. All attorneys' fees in South Carolina are regulated by our Workers' Comp Commission. So any fee I charge in any case, I have to send a fee petition in, and it has to be approved by one of our 7 workers' compensation commissioners. The statute here provides for a fee up to 1/3, and that's a lot of times the case. But honestly, that's a little bit misleading. Unlike, say, a personal injury car wreck case or whatever, where there's a fee on everything recovered in the case. In a workers' comp case, that fee is, generally speaking, only coming out of the final recovery. There's no fee on medical bills. There's no fee on weekly benefits. It's based on that final recovery. So it's up to 1/3 and has to be approved by the commission. You know, I will add this for you, David. You know, that 15% seems really low. That's an access to justice issue. You know, if lawyers don't get paid enough, that it's worthwhile, that they can pay their bills, pay their staff, et cetera, they're not going to handle those cases. And it just like we've seen across the country, or it used to be that way in VA cases. You couldn't hire a lawyer because the lawyer couldn't make enough money to keep the doors open. And so states that have cut attorney's fees really, really low have not done any favors to injured workers by doing that.
David is still waiting on that one case, that one workers' comp case that will allow him to retire to the lifestyle that he so is hoping so. But until that happens, Bill, we'll keep, as we say here, we'll keep chopping wood.
You know, and it happened in Florida. It was the attorney fee structure down there was ruled unconstitutional because it was so low that lawyers couldn't get paid in the cases. So.
Yeah. Well, Bill, let's stay with you for this next topic. We're going to talk about medical arguments, medical disputes. Client calls you up and says, I got hurt on the job. I was working on a construction site and I fell and I've got a back issue. But the carrier says, my injury's pre-existing. It's a case that you like, you want to go forward. What do you do in South Carolina about medical disputes? How do you bring about resolution potentially? What are your avenues?
And that is a scenario we see again and again and again. I'm sure you guys do too. But in South Carolina and in most states, an aggravation of a pre-existing condition is compensable. So what I have to do is I have to get medical causation opinions hopefully from the treating physician, and if not from the treating physician, from evaluating physicians, but I have to have an opinion to a reasonable degree of medical certainty that the injury most probably aggravated the pre-existing condition, resulting in the client's current problems. See it all the time. I mentioned knee injuries earlier. You see it a lot of times with knee replacements. People have arthritis. They don't necessarily have pain. They've been walking around the planet for 50 years and they have pre-existing arthritis in their knees.
Yeah.
Don't really know it. They get hurt, and all of a sudden the employer is saying, or the insurance company is saying, hey, the need for that treatment is not from this injury, it's from the pre-existing arthritis. But it's a matter of medical proof for us.
And David, thank you, Bill. What's your third question to the treating doctor about symptoms? About how do you deal with that question, that issue about these dormant situation or dormant system symptoms, but now we've had some trauma.
Yeah. So Bill, we just have to get from the treating physician is the medical treatment you recommend reasonable, medically necessary, and related to the on-the-job accident. And same thing, if it's an aggravation, we're going to ask that doctor, did the symptoms, maybe, the doctor may not be able to pinpoint when the injury occurred, right? But did the symptoms start after Jim twisted his knee, at work, or did the symptoms start, according to your records, after Bob lifted that heavy box at work? And that's usually enough to get the doctor to link it to the on-the-job accident.
Along those lines, and here's our last topic. How do you bring about the end of a work comp matter? Dave, we'll stick with you. We're unique, Bill, I think you know this, but David, talk about the work comp, I guess the system that brings about closure to claims. How do you get there? Sure.
In Alabama, there's two different ways to finalize a work comp settlement. If you've got a filed lawsuit, you can have your judge approve the lawsuit, and the judge is going to review the attorney fee and make sure that the settlement's in the best interest of the injured worker. Most of our settlements now are getting approved through the Alabama Department of Labor through their ombudsman program. And after the pandemic, during the pandemic, an order was passed that allows the ombuds people to approve all settlements, whether they're pre-litigation or in litigation. So it's streamlined our process. It's allowed our clients to get settlements approved quicker, and as a result, allows us to get our clients their settlement monies quicker as well.
All right, Bill, we'll throw it to you. How do you bring about resolution to work comp matters in South Carolina?
Similar. There's three ways to bring a case to a conclusion. One is by trial, and the other two are by settlement, two different types of settlements. If it's brought to a conclusion by trial, there's an order issued by our Workers' Compensation Commission that dictates what has to be paid out in the claim. And then once that's paid out, there's something called a Form 19 that's filed with the commission showing that money is paid out. With settlements, two types of a full settlement, or what we call a Form 16, which has some ongoing rights for the claimant. With those, Form 16s get sent to our Workers' Comp Commission also for approval. And with what we call an agreement release or a clincher settlement, they used to require commission approval for settlement, but if the injured worker is represented by an attorney, it can simply be filed with the commission. So once it's filed, it's deemed approved essentially. If the injured worker is not represented by an attorney, the commissioner actually has to approve that settlement.
Interesting. It is. We get there. I guess our goals are to get there the same way. We just have different paths depending on our respective states. But Bill, that has, and thank you for that insight. It's brought us to the end of all of our topics, and we're actually on time today, David. So mazel tov to you and your family. Bill, we'll have you on again as a guest, because nobody wants us to go beyond the hour, but we're getting very close to being done on time today. So thank you for that.
Thank you so much. I enjoyed it.
It was fun. David has often nicknamed our show here Work Comp for Nerds, and that this show lets us as practitioners in South Carolina and Alabama respectively kind of nerd out, do a little deep dive, and share some knowledge for folks who are watching this. And against my better judgment and mom's advice, I usually give David the final word on the show. He usually leaves us with something of importance they'll carry us through to our next show. So Dave, I hope you've been thinking about this today.
Bill, I try to inspire people and give back. But I'm just going to go and watch basketball tonight. I've got to do some more scouting for the Alabama game tomorrow night. So that's occupying my evening.
Well, Bill, there it is. I'm sorry that that's left you a little bit low on the advice level. But again, thank you, Bud, for spending some time with us. We look forward to seeing you again in person, hopefully very soon.
Very soon. See you guys. Thank you.
Thanks, Bill.
Hang on just a second, Bill, while we sign off. Guys, as we try to do the third or fourth Thursday of each month, we do our show Work Comp Today, and it every week is something new. We have a new guest next month. We'll do the promos in about 2 weeks. So thank you all who've watched us live. We had several. And for those of you who will catch us on the replay at your convenience on YouTube and other social media platforms, you guys have a good rest of your day and be safe out there.